Callan mentioned, the topic of today's presentation is why a health number is not an Ontario identification number. And in my work over the years as a health information privacy lawyer and consultant, I've received and I continue to receive numerous questions about the use of health numbers in Ontario. People ask me who can use them, for what purposes, who they can be disclosed to, and so on. Frequently, the questions arise in the research context, so Callan thought it would be very helpful if I presented the webinar today. Overall, I'm going to address the nature of the number and its characterization as personal health information under the Ontario privacy legislation, the Personal Health Information Protection Act. We're going to look at the rules under PHIPA regarding the collection, use, and disclosure of the health number, as well as the specific rules that apply in the research context. As Callan mentioned, the presentation should be around 45 minutes, and if questions occur to you after the presentation, please type them in. If after you've received the email with the audio and visual version from the lab in a couple of days, some other matters may occur to you, please feel free to send me an email. My contact information is at the end of the slide deck. First of all, I'd apologize for the little fuzzy picture here. Excuse me. This was taken from the Ontario Ministry of Health site. So you're all familiar with what the cards look like if you're lucky enough to still have held on to your old red and white one, or you've got a green one. And as you'll note, it says, either card is acceptable for insured health services if it's valid and belonging to you. So I have one major objective today, and that is to provide some clarity and certainty around the appropriate management of health numbers in Ontario. I will say before I get into the substance of the presentation that it is quite technical based on the sections of the Act. There's a lot of text on the slides, so I won't address all of it, but they're there for your resource to take a closer look at when we finish up with the presentation today. I think it's really important to sort of go back to first principles to consider exactly what a health number is and to consider why they're issued and what they represent. So if you look at your health card, you will see, whether you've got a red one or a green one, what's called a version code that's associated with the number. And the health number is that number that's assigned to an individual, you, me, and everybody else in the province that's entitled to get one, under the Health Insurance Act. And that health number uniquely identifies you as somebody who's entitled to receive insured health services in Ontario. So what we see is that the OHIP number is the number under the Ontario Health Insurance Plan. So, for example, if you're in a car accident and the police or the other driver want to see your car insurance, they ask you the question to see if you're insured driver and if your insurance, and to what extent, it will cover any damage resulting from the accident. So just like that, your health number indicates that you're somebody entitled to receive insured services. So, for example, when you go to a physician, they ask you for your health number, and the reason, of course, that they do that is so that when your physician bills the Ontario Health Insurance Plan, they know that the plan is going to cover the services that they provided to you because the Ontario government, through that plan, provides coverage for that. So now that we know sort of the genesis of the health number, let's take a look at how health numbers are regulated in the province of Ontario. Before PHIPA came into force in November of 2004, the province thought health numbers were important enough to actually have one piece of legislation called the Health Cards and Numbers Control Act, 1991, that was solely devoted to the management of health cards and health card numbers. And it was a very restricted law that dealt with the use and disclosure of the numbers in a very narrow set of circumstances. When PHIPA came into force in November of 2004, the Health Cards and Numbers Control Act was repealed, and basically the provisions in that act were rolled into PHIPA itself. And the policy objectives dealing with management and restrictions, etc., on the card were continued in PHIPA. And lest there be any doubt about it, the individual's health card number is a specific enumerated element of personal health information, PHI, under PHIPA. So it's clearly identifying information about an individual. So those of you that are familiar with PHIPA will know that it contains a definition of personal health information, and that in those sections setting out the definition, you'll see the specific reference to a health number. In the Act, PHIPA, there is a very, very specific set of rules in Section 31 that addresses the collection, use, and disclosure of health numbers and health cards. And it's very important to remember that these are the rules that you're going to look at when you are considering the use, etc., of a number for any new technology project, any research activity. And because the Act contains this specific section, 34, of rules addressed to the health numbers, they take precedent over any other rules in the Act that deal with PHI more generally. And that's just because there's a rule that says, you know, when there's legislation that deals with a specific thing, it takes precedent over anything in the general case. And if you look at Section 34 and the management of the health numbers, they're set out to deal with various players that are covered under PHIPA. So the rules address management of the numbers by health information custodians, any agents of the custodians, researchers, other non-HICs, and included in the last category is what's referred to as any persons. So what you find at the end of the day is that the health number rules are much broader with respect to who they apply to the general rules in PHIPA dealing with other personal health information. Now, before I go into the rules, I thought it might be important to just review, however briefly, the various categories of players, if you will, that are covered by the health number rules. And I apologize in advance to those of you who are out there listening who have a very detailed knowledge of PHIPA and the way that it applies. But I just thought it was helpful to make sure that we're all talking about the same thing before we go further. So the major players are what we call HICs, Health Information Custodians, and they're the enumerated classes of people or organizations that have custody or control of personal health information as a result of or in connection with performing their duties. So we all know that under this category of HICs, you're going to find hospitals, healthcare providers, pharmacies, and another whole list. The next player that I'd like to speak to briefly is the category of an agent. And an agent's a person that, with the HIP's authorization, will act on behalf of the HIP in respect of personal health information for the HIP's purposes and not for any independent purpose of the HIP's. And this is important for a number of reasons to sort of understand the agent concept. So an agent may or may not be employed by a HIP. So if you take a hospital, for example, all the employees that work in the hospital, for example, nurses, are agents of the hospital, even though as a profession and a professional, they are HIPs in and of themselves. The next thing that's important to remember, and we'll see this subsequently when I go through the rules, is that when a HIP provides personal health information to their agent, that's considered to be what we call a use by the custodian. It's not a disclosure to their agent, nor a collection by that agent. And the reason that this is important, as we'll see later on, is because there are different rules related to the uses of the number as opposed to the disclosures of that particular number. In certain cases, a researcher, for example, may be an agent of a HIP. So if you have a researcher that's working within a larger HIP, a hospital, for example, they will be the agent of the HIP. Alternatively, they may be an independent entity with respect to that HIP. So they may be working in another context. These are kind of self-evident definitions. I've just included them here to round out the way in which the Act defines the various players that have a role in dealing with the health numbers. Now, I'm going to move on to the rules that are applicable to the various entities involved in the Ontario health system and beyond who may require access to health numbers. And given the way that PHIPA is structured, I thought that the easiest way to speak about the rules was to try and understand them from the perspective of those entities that I just described and how they manage the numbers. So if we begin with the custodians, what we see is that the collection, use, and disclosure of the numbers is essentially regulated in the same way as other personal health information. So if you look at the general rules in PHIPA with respect to what a HIP can do vis-a-vis personal health information generally, then what that means is anything they may do in that context, they may also do with respect to their management of health numbers. What is important to remember, though, and very often I find folks sometimes forget that any collection, use, and disclosure of PHI under PHIPA is subject to two overarching principles, what we call the limiting principles. And that is, one does not collect, use, or disclose personal health information if other information would serve the purpose. So, for example, if you're working on something that does not require identifiable information, and it's only identifiable information that's defined as PHI under PHIPA, then you should use de-identified information. The second overarching limiting principle is not to collect, use, or disclose more PHI than is reasonably necessary, so that if there are certain data fields, for example, a data field that includes a health number as a HIC, you shouldn't collect, use, or disclose it unless it's reasonably necessary for that particular purpose. And in this context, what I find frequently happens is people think it's just easier, for example, to provide an entire record to another entity, researcher, HIC, what have you, if they're doing some work together for which the PHI is required. But it's really important to remember, if all those data fields are not required, then they shouldn't be provided. And in effect, I think what these principles do is they really limit the risk that the receiving entity will have, because the less PHI you have, or if you have information in de-identified form, in the event of a breach, then your risk is much more limited. Now, where you see real differences in PHIPA with respect to how it deals with personal health numbers is in those provisions related to persons who are not custodians. And in this section, what I'm going to do is distinguish between the general category of persons who are not custodians, and then I'm going to deal with all of the provisions related to health numbers as they apply to researchers at the end of the session. So if we take it back and look at what are the rules relating to the management of health numbers by the general category of non-custodians. And if we start, which I always do, when you look at sort of the data chain of transactions, we begin with collection and use. And the way in which PHIPA deals with this is it says, if you are not a custodian, you may only collect and use a health number for certain purposes and in the circumstances in which PHIPA describes them. So let's take a look at what a non-custodian can do vis-a-vis collecting and using a health number. So the first purpose is that related to the provision of provincially funded health resources. So it's really important, and that's why I bolded this, the phrase related to, because we know that HICs provide provincially funded health resources, but certain examples of what's intended to be captured here are organizations like summer camps, sports teams, or school boards. So if any of you have children that either go to camp or play on a sports team or certainly go to school, you may have been requested by that entity to provide your child's health number. And we know that, for example, these types of organizations are certainly not health information custodians, but they request the health numbers in the event that there's any treatment or emergency or what have you, and your child may have to receive professional health services, at which time they'll be asked for the health number. So those are purposes related to the provision of the services. Even though the camp or the school may not be directly providing them, if your child does need those services, it's very likely that the school will have to provide their health number. The second purpose for which a non-custodian may collect and use a health number are those for which it was disclosed. So if a custodian disclosed a health number to a non-custodian for a particular purpose, then the non-custodian recipient may use it for that purpose. And the third one that we see on the slide are those purposes related to a proceeding. So, for example, if a lawyer is managing some kind of personal injury case on behalf of their client or a malpractice suit, and the issue is the treatment by a particular physician, it may very well be that the lawyer needs the individual's health number to track it against the particular services that were provided by a healthcare provider. So in those cases, the lawyer is entitled to collect their client's health number. We see that previous slide dealt with those collection and use rules that were applicable to certain purposes. The next set of circumstances in which non-custodians may collect and use a health number relate to categories of persons, not purposes. So under this category, we see 4 different entities for which there are rules regarding collection and use. The first one is governing bodies of healthcare practitioners. And those entities may collect and use the health number for purposes related to their duties or powers. So, for example, if the College of Physicians and Surgeons is investigating a patient complaint against one of their members, they may collect and use the number. The next category is what are known as prescribed planning entities when they carry out their functions. So these are entities that, for the most part, have some kind of research, information-based, analytical healthcare planning function. And these include Cancer Care Ontario, CIHI, ICES, the Pediatric Oncology Group of Ontario, and the Ontario Institute of Cancer Research. The next category is what are called health data institutes, which at the present time is not very relevant because there aren't any yet in the province. And the last one, which may not be relevant for you, but it may be, is archives that are entitled to receive transfers of PHI. And this is sort of a really practical thing because if records, including an individual's health number, fall under the Archives Act, for example, those from the Ministry of Health, and they're being provided to the archives according to the particular schedule, I think you can imagine what a task it would be for folks to go through all of the OHIP records of the ministry or the drug benefit records and redact or mark out the health numbers on those. So that's why that last category is included there. Let's move to the next sort of transactional thing related to non-custodians and health numbers. The general rule is that a non-custodian recipient of a health number cannot disclose that number unless it's required by law or permitted by the regulations. So looking at the first circumstances, required by law or the regulation permits it, we look at things like search warrants, court orders, or mandatory disclosures. So in that case, if you, as a non-HIC recipient of a health number, receives a knock on the door one day and there's an authorized search warrant for your particular set of records that may include numbers, then you are permitted to disclose it if it was, for example, to a police service because you're required by law to do so. What we see in the regulation is a repeat of the circumstances in which you'll recall that these non-custodians could collect and use the health number. So those are for purposes related to the provision of the provincially funded health resources. So if we go back to the example that I used on the collection and use, you as a parent have provided your child's health number to a summer camp, and they're permitted to collect and use it for purposes related to provincially funded health resources. Then that summer camp in turn is permitted to complete that circle and provide it to a healthcare provider in the event that that emergency situation comes to fruition and the summer camp takes your child to a hospital and the hospital is looking for the child's health number. The third scenario is where disclosure is permitted for the purpose of a proceeding. So again, this is a legal situation, and the Act specifically says that the custodian may disclose it for those purposes. So it could be that it may need to be disclosed to a lawyer on the other side, or what have you. Again, I'm going to look at the continuation of the disclosure rules applicable to certain categories of persons. So, and again, you'll hear and you'll see the same entities mentioned in the legislation over and over again. And that's because, and if you think about it, it makes sense, there's generally what I call a closed loop, in the sense that if a non-custodian is permitted to collect and use it for a purpose, it seems to make sense that they should be able to disclose it to another entity for the same purpose. What we will see, however, is that when we come to those rules relating to research, there is a gap. So if we look now at, again, the disclosures that may be made by persons who are not custodians, you'll see that the health numbers may be disclosed to the prescribed health registries. So registries are actually a broader group than prescribed persons, but they're set out there. Disclosures also permitted to the prescribed planning entities for their work, the currently non-existent Health Data Institute, and this is really important too for non-custodians that may have an individual's health number. So say, for example, we're looking at situations with respect to health number disclosures to the WSIB for insured services. That disclosure is permitted. And then again, the final closing of the loop with respect to the archives. Archives are permitted to collect and use the health number, so persons who are non-custodians are entitled to disclose it to them. What I'd like to do now is spend a little bit of time looking at the specific rules applicable to researchers. And what I'm going to do here is deal with the entire data chain of transactions as they relate to this particular group of individuals or organizations, the researchers, because I thought it made more sense to, instead of splitting up the collection and disclosure, sort of take a global look at the situation with respect to health numbers in the research context. So first looking at those circumstances in which researchers may collect and use health numbers. Now, before I go into the details, I do want to stress that this discussion now related to researchers is in the context of a researcher as a non-custodian, and also not as an agent of the custodian. So this deals with a situation where the researcher is not an agent of the hospital, for example. So they're not working on a project on behalf of the hospital as the HIP. So non-custodian researchers. So they may collect and use health numbers if they get the consent of the individual. So if you're doing research that involves direct contact with individuals, and as part of the consent process for that research project, you require, or it's reasonably necessary, to collect the health number and use it for purposes related to the research project. You may do so if you have drafted a proper consent from the individual for the project. And the second scenario in which researchers may collect and use the health number is where the number is obtained through a disclosure authorized under the research provisions of the Act. So say, for example, as part of a research plan and research ethics approvals that have been completed under Section 44 of PHIPA, those are the research provisions of the Act, there is a reference to the research requiring that the health number be disclosed to another researcher. Then the second researcher may collect and disclose it for those particular, for the purposes of that project that's already gone through the Section 44 research plan and REB approval. If we turn now to those situations in which the researcher has appropriately collected and used the health number, and then the issue arises of when may they disclose that number. So we'll go through the four scenarios here. The first one is as required by law. Well, that makes sense. I mean, you'll see with respect to any PHI in the Act, as required by law is a mandatory requirement of any custodians, anybody else that has PHI. So again, if the, there's a legislative requirement, you may disclose it. If the researcher collected the number pursuant to an authorized research plan, so that means they collected it under the second bullet point in the first collect and use scenario, then that researcher may in turn disclose it to a prescribed person, a prescribed entity, or another researcher. With respect to the subsequent disclosure to another researcher, however, there are two conditions that must exist, and they're either or. They're not cumulative. The first one is if the disclosure is part of an approved research plan under 44. So again, this is of the cycle. If the researcher initially collected and used it pursuant to a research plan under 44, and that researcher may in turn disclose it to another researcher whose project has met all the Section 44 approvals. The second scenario in which a researcher may disclose the number is if the disclosure is necessary to verify or validate the information or research. So say, for example, there is some issue about the matching of the particular health numbers vis-a-vis individuals with the same name or similar information. And for the purposes of the research project, it is really critical that you have the right number associated with the right individual. And it may be that you want to disclose it to, let's say, OHIP for the Ministry of Health for verification. Then you're permitted to do so. This particular slide indicates the gap that I referred to earlier in the research context. You'll recall that I said there's usually a mirror image of circumstances in which entities may collect and use a health number and those for which and to which they may disclose the health number. But unfortunately, there is a gap in PHIPA with respect to the collection, use, and disclosure of health numbers by non-custodian researchers. So you will recall, and I'll just flip back for a second, that researchers may collect and use health numbers if the individual has consented to that collection or use. So that's set out on the first bullet point on this particular slide. Now, if we move to the next slide, the first bullet point reiterates that. Yes, you may collect and use with the individual's consent. However, you may not, a researcher may not disclose the health number even if they do have the individual's consent. So if we again look back on the previous slide, you will see that in the second major bullet with respect to the disclosures, there is no mirror image of the first one under collect and use. So that if you meet any of the criteria under the second bullet, you may disclose the health number if you are a researcher. But unfortunately, because of the gap, you may not turn around and disclose the health number even if the individual has consented. And from a practical perspective, there have been research projects and situations that I've had to deal with where this has become an issue. So this is just to give you a heads up about this. And I will say that I've spoken with folks at the IPC, the Information and Privacy Commissioner's Office, about this. And they were involved in amending the PHIPA regulation a number of years ago to permit researchers to collect and use a health number if the individual had consented. And unfortunately, for whatever reasons, the final part of that loop, i.e. the disclosure with an individual's consent by a researcher, was not captured. In my discussions with the IPC, they've indicated that this was not an explicit policy decision, but as I said, something else happened. So perhaps an inadvertent drafting failure. I don't know if anything is being done to close the gap. I doubt it at this particular time, but I just wanted to bring that particular matter to your attention. As if the rules related to health numbers were not complex enough, the legislation also has particular offenses and penalties that relate explicitly to contraventions of the Act related to health numbers. And if any of you have sort of looked at this section of the Act, I don't think many people do, but you'll see that there are some general provisions regarding contraventions dealing with collection, use, and disclosure of PHI. Just like in Section 34, where there is a particular scheme for the management of health numbers under the Act, so too is there a particular scheme for applicable offenses and penalties regarding misuse of health numbers. A couple of things to point out. These penalties apply to any person, so not just entities named under the Act like HIPs or agents. They would apply to non-custodians, including researchers as well. And more importantly, I think, from a practical perspective, the offenses kick in even if there has been an inadvertent or a negligent contravention of the provisions dealing with health numbers. If you have a look at this particular part of the Act, all of the other offenses require willful action, i.e. you willfully disclosed PHI when you knew you weren't supposed to. However, that sort of action, willful intent, if you will, is not required in order to be found to have contravened the provisions of PHIPA related to numbers, health numbers. The fines on conviction are $50,000. However, only the Attorney General may commence prosecution. So, as far as I'm aware, they've never done anything to date. So, from a practical perspective, I'm not sure that one has to be worried about it. I did include the slide, however, just to sort of emphasize that the Act really treats health numbers as a special category of PHI. So to sum up, again, I recognize that the discussion today, or the presentation rather, has been very technical, but I hope that you've seen that the way in which the legislation and the regulations work, that's just the way of the world. It is pretty technical. So I'll leave you with a couple of thoughts before questions. Health number uniquely identifies an individual as somebody who's eligible to receive insured health services. As I said, it's effectively your insurance number for those healthcare services that are funded by OHIP. It's a particularly listed number of PHI under PHIPA, so there is absolutely no doubt that the number in and of itself, even if it is not associated with any other identifiable or other information about an individual, that unique data element constitutes personal health information under PHIPA, and it's subject to specific rules for collection, use, and disclosure by non-custodians, including researchers. So at the end of the day, the really important takeaway, I think, from this session is that the individual's OHIP number, or health number, if you will, is not to be used as a unique identifier for research or other purposes that are not related to the provision of insured health services. So with that, I will open the session to questions. If anybody has any, I'll be glad to take them now.
Well, thank you, Anita. I will now show the Q&A box so the participants can type in their questions. and Anita will be able to pick them up and respond to them.
All right, so the first question is, could we please go back to the first slide pertaining to the collection or use of PHI by persons who are not custodians? Please clarify the second category of persons, as it is rather vague. Khaled, can I go back to the first slide now that we're on the question section?
Yes, I'm doing that right now. If you just give me one moment.
No problem. Thank you. All right. So let me see. The slide pertaining to the collection or use by non-custodians. Wait. No. I think, yes. Thank you. All right. The second category is rather vague. If I understand the question correctly, I believe, are you talking about the circumstance, just a second. Oh, the categories of persons. If this is the slide, to which you're referring, the second category of persons are prescribed planning entities in the course of carrying out their functions. Prescribed planning entities are listed in the regulation. These are what they are. So I believe that's the answer if I understand the question correctly. If I don't understand the question correctly, I apologize, and if you could perhaps indicate what slide number it is, and I'll be glad to take it. All right. There's a bunch of questions here. No, question one, thank you, referred to the previous slide, category of purposes. Okay, so again, if I'm on the right slide, the second category is the purposes for which it was disclosed. So in this particular instance, we have a situation where, for example, a custodian discloses a number to a non-custodian for a particular purpose. So let me see if I can think of something to illustrate the point. Okay, so a custodian, so we have a company. So say we have a company that's not a custodian, but they have an in-house health clinic. So you have a physician that, say it's General Motors, and they are they're working in the health clinic, and they're treating employees of General Motors. And one of the employees has a WSIB claim. And in order to process that claim, WSIB, we're talking about collection and use. Okay, that's fine. WSIB needed to get the health number of that employee for whom General Motors is making a claim in order to process it. So WSIB is not a custodian, but they are permitted to collect and use the health number of that employee in order to process the claim that the company made. Does that make sense? I hope so. Let me just see if I can collect the questions. If a researcher, and again, if I didn't clarify that well enough, please come back to me. If a researcher collects information as an agent, who is responsible to ensure it's properly safeguarded? The HIC, the agent, or both? How would a HIC ensure this is done properly? Very good question. Whenever an agent collects any information on behalf of a HIC, or then regardless of whether it's a health number, you'll recall that I said the provision of information from a HIC to an agent is a use by the HIC. It is not a disclosure. So from a practical perspective, what that means is that ultimately, under the Act, the HIC not only retains control over the information, but they are responsible for anything that the recipient, in this case the agent researcher, for example, does with it. So the HIC is responsible that the information that they provide to their researcher agent is properly used, maintained, secured, protected, etc. The way in which the HIC does that is through an agreement. And that agreement will set out all the requirements that the HIC imposes on their agent to make sure that all of those things to protect, etc., the information are done properly. Sometimes the HIC will give itself audit capability with respect to walking the halls, examining the processes, the conditions under which the PHI is held. Sometimes the agreements may provide for an independent audit of the agent's facilities and management of the PHI, but at the end of the day, when a HIC provides any PHI to their agent, it is the HIC's ultimate responsibility for following all the provisions of the Act. And so they've got to make sure that there is a mechanism by which they can ensure that their agent does all of that. And you'll see, for example, I mean, if you've read orders of the Information and Privacy Commissioner, you'll see that she speaks to this. I think it was, believe, HO010, the order about all the medical records that were supposed to have been shredded, but by mistake went to a recycling plant and ended up floating around the streets of Toronto downtown. And in that case, the company that was supposed to dispose of the records was the agent of, I believe it was a clinic. And the commissioner, I'm not even sure in that case if there was an agreement. So that illustrates a couple of points. You need to have an agreement, and even if there is one, you as the HIC have to make sure that you're covered off with respect to controlling what your agent does. All right. Next question. What about a disclosure of PHI from one prescribed person registry to another prescribed person registry? I don't know if you're talking about health numbers in particular, or the question relates to PHI as a general concept. I believe, and I would have to check, but I believe as a general construct, the disclosure is permitted of PHI. But as I said, I would have to check. If at the end of this you would like to email me the question, I'll be glad to follow up with you. Oh, there's another, oh, here we go. What if they get the health number from the patient and the HIC does not know that they have it? I'm not sure I understand the question with respect to who the they is. If you clarify the situation you're questioning about, I'd appreciate it. Thank you. I think this is the clarification. What if the researcher gets the health number and they don't know if they have the health number? I guess I would say that anybody that deals with personal health information, including a health number, should certainly be aware of the personal health information that they have in their records. I mean, obviously, for example, if you go back to sort of the limiting principles that would apply with respect to a custodian, for example, providing the numbers to a researcher, the disclosure would have had to have been reasonably necessary for the disclosure and consequently for the researcher to have it. So I suggest that there is potentially a process issue problem if the researcher doesn't know the data elements that they have, and in the example, the health number to be able to assess if it's a necessary data element for the particular project.
Okay, I think, Anita, we're out of time now.
There's a whole bunch of questions here. Khaled, I'd be glad to take them. I don't know afterwards. I don't know how you would like to deal with it, so everybody can be addressed.
Well, if you're happy to continue to answering the question, I think there's still quite a few people on the line, so please go ahead.
Okay, let me see. Let me go back. Okay, health numbers specifically. So I think that that's the clarification of the question that related to described entities. If I'm correct on that. All right. So if you look at this, I flip back to the slide. Okay, so you'll see that with respect to collection and use, the prescribed planning entities can collect them in the course of their functions. And you'll see that with respect to disclosures, okay, you'll see that, again, the rules that are particularly applicable to certain categories, and you've got registries and entities in that group with respect to who may disclose. Let's just see. All right, so I think that's that question. That's that question. Okay, this question is, what is your opinion of HO 007, the order provision that required the HIC to securely destroy health numbers that were collected at the H1N1 clinic after the vaccine became widely available to the general public? So if I recall correctly, that's the order that relates to the Durham scenario. I think in this scenario, the situation, there were complicated facts, and I think perhaps it's fair to say that there was a miscommunication between, the way the program was set up and the requirement to collect the health numbers, and whether or not it was necessary, and then some of the other, the health departments, if you will, proceeding with the program and finding out that it really wasn't necessary because the vaccine was available to everybody. And what this does, I think, is illustrate a really good point about the nature and what the card is and why it's not a general identifier. Because if the vaccine was only going to be provided to people who were entitled to receive insured services under OHIP, then it's very fair that the OHIP number should be collected. However, when it's opened up to everybody in the province, so even if you're not insured, then it wasn't required for the purposes of the provision of the vaccine. Because, I mean, you could have taken in anybody. For example, say you had a cousin visiting from Mexico. They could have gotten the vaccine, and they certainly do not are not entitled to receive insured services. So that's how I answer that question. I think there was a question. Here we have something about electronic health records using Not sure all right. Perhaps the first part of the question isn't there, but it says, electronic health records using health numbers as identifiers can be considered for the purpose of insurance-related purposes because HICs use it to access EHR and deliver health services. Still, it seems to me that the purpose for identifying an individual, it seems to me that the purpose is for identifying an individual, and this may not be permitted under PHIPA at face value. Comments. Very good question, and I think I would have to see the structure and the organization of the particular EHR, I misspoke, project in which the health numbers being collected and used and by whom. I suppose as a general comment, I believe there are certain projects out there in which the health number is being used. But I would also say that I would imagine that those projects will have had a privacy impact assessment undertaken, and the issue, that you raised, a very good issue that you raised in your question, seems to me should have been addressed in the privacy impact assessments. Or if there is a system that's yet to undergo that assessment, then it may very well be, if you're involved in the project, that who's ever undertaking that assessment, you might want to bring this point to their attention so they pay particular attention to the analysis of that data element of PHI in the system. All right. No, we're back to question 1. I apologize, guys.
Okay, so I think these were all the questions.
Oh, no, there's more. These are new ones.
Oh, there's new ones. Okay.
These are new ones. And this is one. We don't understand the health. We don't understand the title. Why is the health number not an Ontario identification number? I use that title because it is a health insurance number, as I explained when I set the background. It's not a unique identifier that anybody can use to authenticate John Smith as John Smith because they have the number. That's part of the confusion around. People will use it to say, oh, if they have a health number, then they must be John Smith. And they look at the card with the picture and the number, and that is not the purpose for which the number was generated and for which PHIPA allows one to use it. So that's where the title came from. Just to clarify, non-agent researchers cannot disclose health numbers even to prescribed entities and registries. If you look again, okay, that, let's see, if you look again here, so this is the slide that indicates who the disclosures, who they can be made to and who can make them. For example, you have this whole list of the registries, the entities, the institute, WSIB, disclosures. There's only a couple more. When a non-custodian collects the health card number, does that entity become a custodian? The answer is no. Custodians are defined in the Act, and there is a particular list in the definition section. So a non-custodian can never become a custodian by virtue of the fact that they collect the health number or any other personal information for that matter. All right, here we go again. This is the... Okay, the collection or use of PHI by persons who are not custodians. Okay. Please clarify, I think this is the clarification of the question. Please clarify the second category of purpose, as it is rather vague. I guess the only thing I can say in an attempt to answer your question is that if you have a custodian, then I'm going back, I'll again use the example of General Motors and the in-house health professional, so the physician who treats a General Motors employee, and the company is putting in a WSIB claim because the employee was injured on the job. And in that case, the WSIB will function as the insured to adjudicate the claim. So in that case, the physician, the in-house physician, who is an independent custodian, may provide the health number of the injured employee to the WSIB for adjudication of the claim. In turn, WSIB, who is not a custodian, may collect and use that number for that particular purpose. So I apologize if that's not clear, but perhaps we can discuss further offline if you want to email me afterwards.
Okay, I think Anita will have to close it up here. I think